otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Koehler, and in this episode I am pleased to be joined by Jonathan Pickworth. Jonathan is a partner in the London office of White & Case. And to mark the recent 5-year anniversary of the UK Bribery Act coming into force, Pickworth, along with other lawyers at White & Case, authored a 5-part series titled UK Bribery Act, 5 Lessons in 5 Years. Thanks for joining us, Jonathan.
Thank you.
The questions we're going to be talking about today do relate to the UK Bribery Act, even though FCPA Professor tends to focus mostly on the Foreign Corrupt Practices Act. FCPA Professor has always included discussion and analysis of the UK Bribery Act. And one of the most notable features of the Bribery Act, Jonathan, is its so-called failure to prevent bribery offense, an offense that is at least somewhat similar to the U.S. Respondent Superior standard, given that the UK's standard for criminal liability requires a so-called directing mind to be involved in the improper conduct. And another notable feature, of course, of the UK Bribery Act is its so-called adequate procedures defense. 5 years into the Bribery Act, does the corporate community, in your opinion, know what failure to prevent bribery or adequate procedures really mean?
Mike, I think it's a really good question. I think before answering that one, just to address your point about directing mind, the basic position in the UK on corporate criminal liability in matters outside the sphere of bribery is that a prosecutor would have to prove a very similar sort of directing or pass a very similar directing mind test. But the UK Serious Fraud Office, which is of course the agency in the United Kingdom that is responsible for investigating cases of serious and complex fraud and overseas corruption, says that that kind of test presents too much of a hurdle for it in prosecuting companies. And I think that's particularly so if they're very large companies, because you find there's wrongdoing within the company, but how can you attribute that wrongdoing to one of the directing minds? It tends to be easier for them to do that in relation to small, medium-sized enterprises, and that's perhaps one of the reasons why most of the Serious Fraud Office successes in recent years have been in relation to, I would say, quite small companies like Maybe & Johnson, Sweet Group, Innerspec, and Smith & Usman, not really companies that are widely known. So we do have that directing mind test generally, and this new strict liability corporate criminal offence of failing to prevent bribery is really something very new to English law, although the Serious Fraud Office would like to extend it further, and maybe that's something else we could talk about. But I think with these terms like adequate procedures and what does failure to prevent mean, the problem we've got in the UK at the moment is that these matters are just not being tested. The legislation's been in force for 5 years. There's only been 3 corporate resolutions. That's 2 deferred prosecution agreements, one with Standard Bank and one with an unnamed small, medium-sized enterprise last Friday. And the guilty plea entered into by Sweet Group earlier this year. So there really isn't much to go on. and there's not really yet been any judicial interpretation of it. So I think they're really tricky issues, and I think that if we were looking at something on a proactive compliance basis, one would have to take a very wide-ranging and cautious approach based on an assessment of the risks that a particular company faces doing business around the world. But it's very difficult to give very clear and categoric guidance that would apply to all companies, because it's very much a question of what is each company's risk profile and how do they address those particular risks.
And I should mention that even though the Foreign Corrupt Practices Act is nearing its 40th anniversary, FCPA jurisprudence is generally sparse as well. There are key statutory terms in the FCPA, whether it's foreign official, whether it's obtain or retain business, that have literally only been opined by one legal decision of precedent. There are other elements of the FCPA, whether it's the affirmative defenses or whether it's the facilitating payment exception, that suffer from that same sort of judicial vacuum. Now, given that the UK has recently adopted deferred prosecution agreements and have used DPAs twice now in the last 6 months or so to resolve alleged instances of corporate bribery, do you think these key terms, failure to prevent bribery or adequate procedures, are going to be given any greater meaning over the next 5 years?
Well, let's hope so, because they haven't been given much clarity yet. All we know is that if a bribe is paid by an employee or indeed any associated person, that could be any third party or agent of a company, then we know that it's going to be relatively straightforward for that company to be prosecuted, and certainly much more straightforward than it was under the old regime. So it would be very helpful to get some clarity. There is some Ministry of Justice guidance that was put in place just before the Act came into force 5 years ago that was supposed to help companies understand what's meant by adequate procedures, but it's not really the most useful document. And unless and until we start getting a real throughput of cases, I think it's going to be very difficult to draw any hard and fast conclusions about what these terms mean. And you mentioned a moment ago that 40 years of FCPA jurisprudence hasn't perhaps revealed that much. I think it's a very fair point, and some people criticise the Serious Fraud Office for not having prosecuted yet more companies under the Bribery Act, and I think that's an unfair criticism. I think these things do take time to come through the system, and the Act has only been in force for 5 years, which in the whole scheme of things is not a particularly long period of time.
Yeah, and I completely agree with that point, and have been writing about that over the last few years, as well as the Bribery Act turned 1, turned 2, turned 3. Many of the activists in this area were yelling and screaming, where are the prosecutions? But to your point, even in the United States, we can, I guess, question why it takes this long, but on average, FCPA scrutiny tends to take 2 to 4 years, and it's not uncommon to see 5 or 6 years. But we are at the 5 year.
I think there's a good reason, Mike, why it does take so long, and that's because the Serious Fraud Office, certainly from this side of the pond, the Serious Fraud Office is only responsible for dealing with the most complex and serious cases, and those tend to be the ones where the offences of bribery are committed across borders, and the Serious Fraud Office, in taking an investigation forward, has to get evidence often from a number of jurisdictions, and that inevitably takes time, and that's not necessarily their fault. So I think there's really good reason why these things take a while to come through the system.
Yeah, it'll definitely be interesting to follow this over the next 5 years and thereafter. Now, regardless of some of the key terms that are not adequately perhaps defined right now, you write in one of your pieces concerning the Bribery Act that no one can doubt that the Act, and in particular the threat of the corporate offense, has had a huge impact on how bribery and corruption compliance is now viewed. by most companies that carry on any of their business in the UK. Now, measuring things in this space, bribery and corruption space, is always sort of difficult. But can you describe this huge impact, whether anecdotally, empirically, or otherwise, that you write about?
Yeah, I mean, we see a lot on the ground in terms of how companies are dealing with compliance, and it's certainly the Act has had this effect that anti-bribery compliance is on the boardroom agenda like nothing we've ever seen before. I think what I'm hearing on this is that most people, even a lot of Americans, now see the Bribery Act as the gold standard in terms of what international companies need to live up to in terms of their bribery compliance. It also has extremely broad jurisdictional reach. So for this corporate offence that we were just talking about to apply, the question you need to ask is, does this company carry on business or any part of its business in the UK? If the answer to that question is yes, then any act of bribery by that company or on behalf of that company is caught potentially by the jurisdictional reach of the Bribery Act, even if the transaction in question had nothing to do with the UK, and even if no part of the Act involved took part in the UK, and even if no UK citizens were involved. So it's really very far-reaching. There are nonetheless still some companies that would see themselves being technically outside the reach of the Bribery Act. So perhaps one could say they don't need to bother complying, but that's a dangerous path to follow because, of course, if you're not going to live up to the Bribery Act standard, you've got to be pretty confident that you're never going to carry on any part of your business in the UK. But there's actually an even more important commercial driver for most businesses, which is if you want to partner up or do business or act as a supplier or a third party for any large company or even a small company that carries on business in the UK, then you will be expected to live up to the Bribery Act standards because those companies that you're working with will have to comply with the Act, and they will be making sure that their associated persons are compliant. So that sort of dripped down and really is starting to have an impact on companies, even those that don't think that they're technically caught by the jurisdictional reach of the Act. And of course, the other aspect in which it's having a huge impact is that these are the sorts of things that need to be looked at in connection with every transaction, every M&A piece of work, any financing, the issuing of prospectuses, certifications from suppliers, those sorts of things. Investors are interested in this. Private equity houses and institutional investors, they want to know how the companies that they invest in are behaving. And then finally, Mike, there's these sort of discovery factors, which is another way of saying that these things now have a real habit of coming to the surface if there's a potential issue with money laundering disclosure obligations, whistleblowing, mutual legal assistance between enforcement agencies worldwide. And of course, with a recession possibly around the corner, perhaps it could be said that these things are even more likely to come to the surface as we find ourselves in a world where there's even more disgruntled employees than there may have been last year. Those are the people that tend to blow the whistle.
And the point you raise is, again, relating this to the FCPA as well, because it's similar, is, bribery and corruption law, whether it's the FCPA or the Bribery Act, has what I'll call two sort of impacts. One is the hard enforcement impact. In other words, how many actual enforcement actions are there? How many individuals or companies have been caught. And obviously that's an important measure of the success of a law. But as you rightly know, that laws like the Bribery Act, like the FCPA, have really a greater, what I'll call soft enforcement impact, in that corporates, conform their conduct, are motivated to spend resources in best faith efforts to comply with the law. And that is very difficult to, empirically measure, but we know it's happening. And your, insight on that as to perhaps what your clients are doing is notable. Now, another topic addressed in your series is what are the best incentives to self-report bribery and corruption offenses. In both the DPAs that have been used in the UK, the Standard Bank DPA from last December, and the very recent DPA against this unnamed company, the presiding judge, who is the same judge in both cases, opined that the companies were far better off by self-reporting. And the question I have is, how do we know that to be true? In other words, if the companies did not self-report, it's entirely possible that the FCPA, or excuse me, the SFO, would never have learned of the improper conduct. And if that's the case, the companies might have been better off thoroughly investigating, implementing remedial measures, and undertaking compliance enhancements all internally and without reporting to the FCPA. So the question is, how do we know that companies are necessarily better off by self-reporting to the SFO?
I think you make a good point, and I'd have to say that if the SFO were on this call now, I think they would disagree with your comment that you might be better off because they may never hear about it and they therefore may never end up being investigated. So should you keep your head down, the SFO would say no. The SFO would also say once they find out about it, they can go to the government and get funding to investigate and, if necessary, prosecute cases. So they say that's not a problem as well. But, of course, the reality is they cannot possibly investigate every single case. And like any agency anywhere in the world, they do have their own pressures on funding. And that's why self-reporting is so important. And I think that's why the US system has been so successful. And I think to achieve a real throughput of cases, some more thought needs to be given as to how companies can be better incentivized to self-report. And just to give you an example, under the previous regime, the SFO before David Green became director, generally speaking, a company that self-reported an act of bribery could be reasonably confident that the matter would be disposed of by way of some kind of civil settlement, as long as they did a proper self-report and owned up to whatever had gone wrong. So there would be no criminal prosecution, but they might have to pay over a penalty of some sort, but they wouldn't end up with a criminal conviction. The SFO recently has moved right away from that and says the incentive to self-report is a deferred prosecution agreement. But I'm personally just not convinced that the DPA is the same kind of incentive as a civil settlement. And quite frankly, it means if you're sitting in a room advising a board of directors now about some act of bribery that's perhaps been uncovered, there might be a tendency within the boardroom for that company to decide that what they want to do is investigate the problem fully, get rid of the wrongdoers, upgrade their compliance program, maybe compensate customers if that's appropriate, and then move on without doing the self-report bit. And I don't think that's necessarily in the interest of anyone to have a system where companies are disincentivized from self-reporting. It also has the advantage, if you can persuade companies properly to come forward in this way, that it actually relieves the funding pressures on the SFO, because the company is incurring the financial burden of the investigation itself, and that burden is not being borne by the taxpayers. And what that achieves is it allows the Serious Fraud Office to devote its precious and limited resources to those cases that most need it, so that it can focus on those companies that aren't coming forward and aren't recalcitrant and perhaps better deserve to be investigated and face some kind of criminal resolution rather than a civil settlement. So I think all round incentivization for self-reporting is very, very important. And I just feel at the moment that the DPAs don't necessarily do that. I don't think that the financial rewards of a DPA put a company in any better position than they necessarily would be if they entered an early guilty plea on a prosecution itself. And the DPA, it's a terribly difficult thing to achieve. We've had 2 deferred prosecution agreements now in 2.5 years since they became available. Someone asked me the other day if this meant this was the start of a trend, and my response to that was that anyone who thought this was a trend really needed to get out more, because 2 in 2.5 years doesn't really seem to me to be astonishing success. Perhaps we'll see more throughout the rest of 2016. That remains to be seen, but at the moment it doesn't seem to me to be a particularly easy tool to use, and not a particularly great incentive for a company to come forward.
Yeah, you mentioned earlier in your response to that the SFO would articulate that, hey, we are going to find out about this, and I was going to say that the DOJ and the SEC have long said the exact same thing. But I think what was interesting about the DOJ's pilot program in April of this year is finally the DOJ rightly conceded that, hey, we aren't finding out a lot about this by ourselves, and thus we need to motivate self-reporting even greater. So if the goal is to motivate self-disclosure, it sounds like, if I'm hearing you correctly, that you think the UK perhaps has taken a step back, not a step forward. You mentioned previously under prior SFO Director Richard Alderman, self-disclosing companies could reasonably expect a civil settlement, but perhaps the DPA regime, which was at least marketed, I guess you could say, as motivating self-disclosure, it sounds like you think it might be a step backwards.
I think it's a step backwards, but I think your view on the view you would have on this really depends on whether you think that philosophically there is a public interest in prosecuting companies. Because if you think that it's right as a matter of principle to prosecute the companies themselves rather than simply the individuals who are engaged in the wrongdoing, then perhaps there is an argument to take this all the way down the criminal regime in some way, shape or form in every case. But my own view is that criminal offences are committed by individuals. They're not really committed by companies. I suppose if you have a company that is rotten to the core, uncovers wrongdoing, but keeps doing it and allows the wrongdoers to stay in place and does all sorts of bad things, then perhaps that company needs to be prosecuted. But in those circumstances, the SFO ought to be able to satisfy the directing mind test, and such companies, frankly, should not be eligible for a DPA in any event. So I think so much of one's view on the right approach to these sorts of things depends on whether, as a matter of principle, you think it is right to prosecute companies. And my main concern over that is that if you think of a bank or a major energy company that is being prosecuted in relation to a bribery offence that has taken place probably 6, 8 or even 10 years ago, when all the wrongdoers have long since departed, whose interest is really served by prosecuting the company? Because the only interests that really get damaged by such a prosecution of the corporate entity are the interests of, I suppose, first of all, the shareholders, which might be your pension fund and mine, and pension funds of any listeners to this podcast. It'll probably be the current employees, often the low-level employees, who will end up getting laid off as a result of the lack of business the company can win following its prosecution, and maybe it'll be the customers of that entity itself as well. And it won't be the people who actually engage in the wrongdoing, who've long since gone, who probably should be separately looked at by the relevant agencies.
And here in the U.S., our standard of corporate criminal liability is comparatively more lenient than in the U.K. and indeed really the rest of our peer nations, and that discussion has been taking place in the United States as well. One of the points you raised, I think, is a very good point, and that is the Bribery Act, the FCPA. These are all specific statutes and sometimes have specific policies and resolution vehicles used, but But at the end of the day, I think you're right that one starting point on so many of these discussions is, what do you think of corporate criminal liability? Another starting point that I think is very important is, do you view corporations as inherently good, making good faith efforts to comply with the law? Or do you, as some people do, view corporations almost as inherently bad, who are looking for loopholes at every turn? And these general topics, as you rightly note, I do think drive the discussions in many of these areas. So the starting point that a person, a commentator, an organization has is very important.
Well, I agree with you, but it's also would be right to say that even if companies are looking for loopholes, again, it's not a corporate entity itself that looks for a loophole. It's the managers and operatives of the company that look for the loopholes. So it's human behaviour we're talking about rather than corporate behaviour, and I think sometimes there's some confusion as to where the criminal liability should rest.
Well, thanks for joining us, Jonathan. The UK Bribery Act has indeed turned 5. It's a moment to reflect, a moment to pause. It's a meaningful anniversary. But as you noted in some of your responses, it's just the beginning, perhaps, of a new regime in the United Kingdom. So thanks for joining us today to share your thoughts.
Thank you very much, Mike.